Okay.
Welcome, everyone. Welcome, welcome, welcome in. Thank you for joining us today. Welcome in to Tuesdays and Thursdays with Care Patrol. We're so happy that you've made time today to learn about our topic, which is Elder Law 101. Now, some of you may have tuned in believing that you were listening to a Medicaid presentation, and that's my mistake. Not only did I confuse the dates when scheduling, I also failed to correct my mistake on the website until just yesterday. And so if you think you're going to get a Medicaid presentation, you certainly can. We did this with our speaker, Bill Nolan, earlier this month, and it is recorded on our website at carepatrol.com /advisors/Sean Barnes. But so that Medicaid presentation exists. You can get that information. However, today you will not. You will hear Bill instead talk about Elder Law 101. And so everyone who's on the call is muted, as you may remember.
I'll call you at 1 o'clock, okay?
And Bill may not know that he's on the phone, but that's funny. Hey, Bill.
Yeah. Sorry about
Remember to mute yourself when you're on the phone. That was funny. No worries. Yeah. So I'll introduce you now. So this is Bill Nolan, and he is an elder lawyer. And some of you may ask, well, what does that actually mean? Bill will tell us today what that means and how long he's been doing it, and exactly, what sort of things that he's able to do for clients to, enrich or enhance or minimize harm to them. So that's our topic today. It's not Medicare or Medicaid, rather. That's my mistake. Today is Elder Law 101. Hello to everyone. Thank you all for being here. As you may remember, we use, in order to make this a live CEU for you all, I'll do some housekeeping. In order for this to be a live CEU, we do a Survey Monkey evaluation following the presentation. The Survey Monkey opens, and once opened, there's a password, and the password we give out about 40 minutes into the presentation for those of you who are new. And the reason that we do this is to make sure that we can say to the Board of Social Work and to the Board of Nursing who credential us that you were here and you attended and it was live. So we give you a password to get into the survey, or a code word. We may call it code word. It's password, code word. And I'll give that out about 40 minutes into the presentation. You'll use that with this Survey Monkey link that I've posted in the chat room, and I'll post it again. I'm going to read it very quickly for those of you on the phone or who are able to take notes. It's https://www.surveymonkey.com/r/ all uppercase WVR522Y. So that's our Survey Monkey evaluation link. I'm going to read it one more time for those of you on phone who are unable to witness or see the chat room. It's https://www.surveymonkey.com/WVR522Y. And here it is, Cassandra. I'm going to post it again. It just keeps moving up the chat room. And the reason is so many of you, thank you, are chatting today and introducing yourselves. And I hope you'll continue to be talkative as Bill is talking. So I've given us our housekeeping. We have an evaluation. There's a password. Listen for it, please, or look for it in the chat room, or ask me about it afterwards. The survey is open today. It will close tonight. And I'll get out your CEU certificates, which are digital and paper tonight at some point. But right now, given that we're well into our presentation and we have quite a number of people still joining, I'm going to let Bill get started. Bill, and please enlighten us as to what is elder law.
Great. Thank you, Sean. I appreciate you doing these continuing events too. It's great to have an opportunity to get the word out and learn what other people are doing. So I like to watch even when I'm not presenting. My name is Bill Nolan. I have been a lawyer since 1982. And I've been practicing elder law for quite a few of those years. Back in 1997, I think it was, there's another lawyer in town, Lynn Campisi, who started the speaking circuit. And she was talking at that time, this was 97, about something called elder law. And the rest of us lawyers are looking at her like she's speaking, ancient Greek or something. We had no clue what that meant or why it was important or what would make it different than anything else. Essentially, though, Lynn kept plugging away and decided to set up a section in the Alabama bar called the Elder Law Section. And Lynn and I and a few others were the charter members of that section. So we've been talking about elder law since 1997 or so. Most areas of the law, bankruptcy, divorce, criminal defense, real estate closings, adoptions, that tends to focus on what the lawyer does. That is, I practice criminal defense. I get criminals out of trouble. I practice divorce. I help couples or individuals who are going through a divorce. Or bankruptcy, well, a person has problems there. I help people get settled so that they are no longer being hounded by creditors. Elder law is different. Elder law doesn't talk about what we do. It talks about who we serve. So it's a little bit different than the other areas of law because elder law can really include almost anything out there in the law that affects seniors. I've broken it down in this PowerPoint into some of the major areas of focus, but these are just sort of suggestions, not like that line from Pirates of the Caribbean about parlay. It's a suggestion and not a requirement. So we're going to just get into this a little bit and please ask any questions you might have. Happy to answer them any way I can. The major areas of focus in elder law tend to be these five: veterans benefits, Medicaid, both the planning part of Medicaid and the application part of Medicaid. Guardianships and conservatorships is we probably spend 30 or 40% of our time in this area. Estate planning, and of course, estate planning for seniors is different than estate planning for many of you who are still, you have young children, you're growing your estates, and you have many years ahead of you. When you're working with a senior, they may have a much shorter time window to plan in, and sometimes capacity is an issue where it would not be in your case. So estate planning is a big part as well. And lastly, probate of estates after someone's died. If it's an individual, well, it's different than if there's a surviving spouse involved too. When you think about the whole planning process, though, I would bet you that many of you started saving for your retirement really from your very first paycheck. A certain small percentage is carved out to go into your 401k or your 403b, or you might have an IRA that you're funding every year. So even though you're not going to retire and need that money for 30 or 40 years, maybe, you've started planning for that time in your life called retirement, and that's great. When you take a vacation, we're getting into the vacation months, at least many of us think about, well, where do we want to go? How much money do we have to spend? Where do we want to stay? What do we want to do for food? Do we want to cook our food? Do we want to go out to eat at restaurants? If so, which restaurants are we going to plan to go to? Do we need to make any special reservations for events or activities? We plan our vacations months in advance of actually taking them. You don't just one day wake up and say, I'm going on vacation and and go to the airport and buy a ticket to Hawaii and hope there's a place to stay when you get there and all that. That would be crazy. Every Thanksgiving or Christmas or Easter, we plan about who's going to come and what are we going to eat, where are they going to sit, and what times are we going to be doing this, and who needs to bring what. We plan those events, even though they're, they may be months out. We're still planning them. So planning is a big part of our life, even though we maybe take it for granted. Many people will enter this time in their life called retirement and not have a plan in place. They have a plan that they've been funding, an IRA or 401k. So they have money saved, but in their mind, that's all they need to have in place. If I have enough money when I retire, everything will be okay. Well, that's not true because of the profession you're in. Financial planners, I hope I'm not going to offend anybody who's in the business. I think they share some responsibility for that misunderstanding, because a financial planner will say, save as much as you can for as long as you can and spend as little as you can and work as long as you can, and then you'll be okay in retirement. Well, retirement is about a lot more than just money. I mean, that's a big part of it. Don't get me wrong, but people have to face all sorts of challenges in retirement that money alone will not fix. One of those is, what happens if I lose a spouse and all of the benefits that come with that, support and assistance and all that. Well, yeah, I mean, you can hire somebody to be your caregiver, but that's not the same thing. What happens if I lose my eyesight or my hearing or my mobility? How am I going to deal with that? What happens if I have to leave my house? Where am I going to live? Those are all challenges that people have to face in retirement that money alone won't fix. So part of elder law is helping people with all of those tough decisions maybe they hadn't thought about, or maybe they enter retirement and all of a sudden they're faced with a diagnosis of dementia. What do you do? Money alone is not going to fix that problem. So that's really a big part of what elder law attorneys do. It may include one or more of these five. People just don't plan. And I wish we could get involved in the discussion with clients a lot earlier than we do, because oftentimes we're called in as crisis managers rather than as pre-planning coaches, I guess you'd call it. Let's tackle these one at a time, though, so you'll understand sort of how we go about what we do and give you a little bit better understanding. Veterans benefits, a huge part of what we do, not as big a part as it was 3 years ago. I wish it were, but the VA changed their rules about 3 years ago, and that rule change effectively eliminated 90% of the veterans claims that were being processed up until then. So the VA had a huge bottleneck in VA benefits. It was sometimes taking a year to get VA benefits approved. It wasn't a question of the veterans scamming the system. It was a question of a lot of veterans from World War II and Korea were aging out. So now they were entitled to the benefit, and the VA didn't have the staffing in place to handle the processing. So rather than add to staff, they said, let's change the rules and make it harder to qualify, which they did. And now we don't see nearly as many veterans claims as we used to. But there are two types of veterans claims that that you oftentimes see. Let's see. Service-connected disability and the improved pension benefit, sometimes called aid and attendance. Service-connected disability claims are where a person has sustained some injury as a result of his or her active duty service. It could be deafness from loud noises. It could be Agent Orange exposure. It could be shrapnel. Oftentimes it's PTSD. Those benefits are awarded based upon a percentage assessment of disability. It could be 10% to 100%. And the VA does their medical review and assigns a disability rating. And that service-connected disability is irrespective of a veteran's age, income, or assets. So you could be a 22-year-old vet and get a service-connected disability of 100%, or you could be a 75 or 80-year-old vet who all of a sudden learns that he has some diagnosis that's directly related to his exposure to Agent Orange way back in the Vietnam War, and get the benefit. And it doesn't matter whether you're married, single, doesn't matter how much money you have or what your net worth is. It's awarded based upon your disability finding or rating that the VA comes up with. The second type of benefit is called the improved pension benefit. And this is where we see probably more of our clients. People call it aid in attendance. Well, the true name is improved pension benefit. And what it is a benefit that is awarded to wartime era veterans who served at least 90 consecutive days active duty service, one day of which was during a defined wartime period, World War II, Korea, Vietnam. They have to be over 65 or totally disabled, and they have to now be incurring additional unreimbursed medical expense like caregiving expense, whether a family member is providing the care or a professional is providing the care. Or they could be in assisted living, memory care, or a skilled care facility, because every dime they spend in an assisted living or higher is considered an unreimbursed medical expense. If they meet those requirements, and there are also an income and an asset requirement, those are the ones that effectively got rid of the bottleneck. You can't have assets in excess of around $130,000, not including the value of your home or your car and your personal property. If you have IRAs, 401k, stocks, bonds, mutual funds, things like that, that exceed 130,000, give or take, you're probably over-resourced by the VA and you won't get the benefit. So, and the income requirement is also tough. What it says is they don't care how much income you make every month, you and your spouse, if you're married, as long as your total monthly income is met or exceeded by your unreimbursed medical expense. So if you have a married couple who have moved to assisted living, or they've moved to independent living, let's say, and they have caregivers helping them every so often, if their income is, say, $4,000 a month, but the cost of independent living and caregivers exceeds $4,000, well, the veteran should get the full monthly pension benefit, and that's about $2,400 a month, tax-free. So it's a nice benefit to think about, but it's harder to get because a lot of veterans these days have more than $130,000 in the bank. But there are strategies that you can put into place as long as the veteran is willing to wait to qualify for the benefit in the future. Used to be that this benefit was one that, let's say a veteran has broken his hip and he's gone to the hospital and he has developed pneumonia, and now he's shaken the pneumonia and his hip is mended a little bit, but they send him to rehab. Well, his kids would come to us, generally his kids, maybe his spouse, and say, Dad is going to need more care than he can get at home by himself. What can we do to qualify for the aid attendance benefit? Well, in the old days, we could set up some trust and transfer money to trust, and then the next day he was eligible. Nowadays, you have to wait 3 years to do that. So rather than crisis planning for veterans, now it's more of a proactive planning where a healthy veteran would come to us in his 70s or 80s and say, I'm doing fine now, but who knows what the future will bring? What can I do to qualify for the VA benefit whenever I need it? Well, we have to do some planning 3 years in advance to make that happen. The other benefit that I didn't mention here is the VA nursing home benefit, which is available to all wartime era vets. There's a long waiting list, but if a veteran is receiving even $1 a month under this improved pension benefit, his VA rating changes from a 7 or an 8, which is the lowest, to a 4, which is pretty high, really, on the VA's rating scale. So it effectively moves the veteran to the head of the class in a way, fast tracks them. At least that's the way it's supposed to work. So that's the VA benefit. we used to see a lot of World War II vets, and then that kind of tapered off. And then the widows of World War II vets started picking up the slack, and that's tapered off. And now Korean War veterans and their widows are the ones we're helping out. And the very front end of the Vietnam era, which was 63, 64, we've seen a few of those as well. So it's a great benefit. We ask everybody who comes to the door, are you a veteran? And we talk about this before we talk about anything else. The next area, which we talked about a couple of weeks ago, was Medicaid. And always happy to answer questions about Medicaid. There's a typo on here. I just noticed it. In the green area, it says Medicaid application. It should be a parentheses, AKA crisis planning, not a 9. I must have hit the wrong key. Forgot to hit cap. Medicaid planning, the Medicaid umbrella includes both pre-planning, that is, what can we do as a family to minimize the life savings of the Medicaid applicant having to be used up before Medicaid begins. That's pre-planning versus crisis planning, which is mom's in rehab, they're going to kick her out next week, and she has to go to skilled care. What can we do? That's crisis planning. There's really not nearly as much you can do to help somebody in that situation as pre-planning. Medicaid has a rule that could be interpreted to say a family is welcome to transfer as much of their assets as they want to, as long as they do so at least 5 years before submitting a Medicaid application. That's called the Medicaid 5-year look back. Medicaid says, if you transfer an asset within 5 years of asking for our help, we're going to take a look at that transfer and possibly rule that it was a disqualifying transfer, and you have to get the money back. And then you have to use it to pay for your nursing home care before Medicaid begins. So if you have a patient, a client, and she has given $100,000 away to her kids and applies for Medicaid within 5 years, Medicaid's going to see that. They are very good at finding transfers. I mean, you can complain about government's inefficiency, but Medicaid is very efficient about finding any and all transfers. And they'll say, we noticed at 4 years, 11 months, and 29 days ago, you transferred this CD. Where did it go? Oh, I gave it to my kids. I didn't want it to have to be used for nursing home care. Well, Medicaid's going to say, you got a simple choice. You can ask for it back and then spend it down on your nursing home care until you're down to $2,000, and then we'll talk again. Or we'll just impose a penalty on you and approve you for Medicaid to begin after your penalty is run. And if you transferred $100,000, let's see. That would be about a 15.5-month penalty. So what that means is, congratulations, you've been approved for Medicaid. It begins 16 months from now. Meanwhile, the family has to privately pay for that care. So that's how the 5-year look back and the penalty imposition works. It therefore makes a lot of sense for families who may have to face nursing home care down the road to put some plans in place now while they're still healthy, because once you get into that 5-year window, there's very little you can do to protect assets from having to be spent prior to Medicaid beginning. The Medicaid application process, and any of you can pull up the Medicaid application, go into the state Alabama Medicaid agency and pull that application up. It's pretty sophisticated. It's comprehensive. It's not an easy application to get through. It's always good to use a consultant on that. And last couple of weeks ago, we had Pam Strickland co-presenting with me. She does nothing but Medicaid application. She doesn't work for me. She's a small business owner, and she's a consultant, works with anybody, families, lawyers who need help with a Medicaid application. She does great work, probably has had more approvals than anybody else in the state, other than a Medicaid person themselves, and knows her stuff. And there's still, what you'll end up with, and I don't mean to offend anybody who works for a skilled care facility, because you've got lots of balls you're having to juggle as an employee there. But many skilled care facilities have someone on their staff who will assist a family with a Medicaid application. That's one option you can go with. Is, let's say that you have a loved one at Fairhaven or St. Martin's, and they have somebody who, along with the other job she has, will help people with the Medicaid application. That's cheap because it doesn't cost anything. And you hope that it's done correctly. That's one option. The other option is you do it yourself. And then the third option is to use a consultant like Pam.
Bill,
Yeah.
someone asked about Pam. Tell them a little bit about Pam and share her, if you don't mind, as a resource for folks that have this need for someone like her.
Sure. Pam, her name is Pam Strickland, and her business is called Medicaid Application Processing Services, MAPS, MAPS. And Pam worked for me as a paralegal for years. And for whatever reason, she actually enjoyed doing Medicaid applications. Now, it's probably one of the most tedious things I've ever done, a Medicaid application. She enjoys that kind of tedium. And she came to us years ago and said, you know, I like working here and all, but, you know, what I'd like to do is start my own business doing Medicaid applications. And of course, for her, that meant now she could work for any lawyer out in town who's doing Medicaid, not just us. Well, we hated to see her go, but I mean, you can't hold people back. So she started doing nothing but Medicaid applications probably in 6 years ago. And I don't know how many she's done since then, but I have her contact info here somewhere. And I'll be happy to give it to you. If you want to shoot me an email, I can send you her contact info as well. She's easy to work with. I don't know what she charges, but if she gets you Medicaid even a month before you're able to, you know, she saved you $7,000 or $8,000. So it's well worth the fee that she charges. Medicaid is not an area that I think anybody should really tackle without somebody in their corner. It's very easy to make a mistake, and Medicaid is not the most forgiving agency. I know we have probably somebody here with Medicaid. She was here 2 weeks ago. I don't mean to offend, but if you make a mistake, let's say that you transferred an asset and Medicaid caught it, and you said, well, gosh, we didn't know any better. Nobody told us. That's not going to buy you anything. Medicaid's going to say, well, that's, you know, you're tough luck. We're either going to penalize you or you got to get it back. And if you gave $100,000 to your adult child 4 years ago, what do you think the chances of getting that money back now might be? Probably slim to none, you know? So Medicaid is not very understanding about transfers and things like that. Don't want to make any mistakes. In other words, you want to clean up your act as soon as possible. Another thing that people will oftentimes do and not know any better is, let's say that your mom has moved in with you and she's living in the spare room you have, and she's not driving anymore because her health has declined. So every now and then you'll go to Walmart or Target and buy stuff for her. You say, Mom, I picked up a bunch of stuff you need. I'm just going to reimburse myself from your checkbook. And you write a check on your mom's account because you're her agent under her power of attorney. You write it to yourself for whatever you picked up at Walmart or Target, and don't think anything more of it. 4 years down the road, when you're applying for Medicaid, Medicaid says, hey, we see all these checks payable to your daughter. What are they for? Well, daughter says, I guess they were for Walmart and Target. I mean, who knows? Well, Medicaid's going to say, we need to see the receipts. And if you can't show receipts, Medicaid's going to consider that to be a transfer, a gift from mother to daughter, and that's going to be added into your transfer penalty amount. So little things like that, if we get in the mix early enough, we can give people some guidance. This is how you need to handle finances. This is how you need to quit making gifts to your kids and grandkids, because those are just going to be added up. Don't add people to your accounts or transfer money to them. Little things like that can make a huge difference down the road in a Medicaid application. And people just don't know any better. It's not like something you would think about. The next area of practice would be guardianships and conservatorships. Now, a guardianship conservatorship is a court imposed process where a person, and we only deal with seniors, guardianships are also big in family court for minors. We don't ever get involved in those. But for a senior, let's say that your dad is a widower and he starts doing something dumb. He starts giving away money to the Publishers Clearinghouse, or he starts acting strangely in some way, not taking care of himself, making poor decisions.
Bill, we have a question. Bill?
Yeah.
Hey, we've got a question. It's are applicants penalized if they have always had joint accounts with their children?
The way this is on Medicaid, I suppose. On Medicaid applications, Medicaid looks at a bank account, a joint bank account, and their question is, who put the money in? And usually a child is added to a parent's account for the parent's convenience, so that the child can continue paying bills and managing money and all that. Rarely do the children put money into that account, but the children certainly can take money out. Medicaid looks at who put the money in. That's who the money belongs to, regardless of how many people have the option to take it out. So it would basically all be mom's money and all have to be spent down. Now, VA, incidentally, is different about that. If you had a $100,000 account and you added one child to it, well, now only $50,000 of that $100,000 is attributable to you for the VA asset purposes. You added two people and only $33,000 is attributable to you, but Medicaid doesn't see it that way. So in a guardianship conservatorship, a guardianship is necessary when a person needs another person to help them manage their personal affairs. That is, where they live, who they visit with, what they eat, what they wear, who they spend time with. And a conservatorship is necessary when a person needs help with managing their financial resources. So oftentimes in our case, we see both, but you could have either or. So if your dad is acting out, he's not, he's not acting responsibly, won't go to the doctor, goes outside on the porch naked, plays with guns, irresponsibly, whatever it might be. Those are all trigger, no pun intended, trigger events that would cause you to think about maybe it's time for a guardianship conservatorship. When you become a person's guardian, they actually lose their independence. So the court looks at this pretty seriously. They're not just going to award a guardianship lightly. Not like in that movie that was out last year. I forget the name of it, but it was out in California, Guardianship's Gone Wild, where people were literally cleaning people out without any kind of oversight. In a guardianship or conservatorship, the way they begin is a family member usually would come to us and say, Dad's acting crazy. He's not doing this or he's doing that when he shouldn't be. So we prepare a petition for guardianship conservatorship, and we have to allege certain things like Mr. So-and-so is an 81-year-old resident of Jefferson County, address blankety blank, born on such and such date, diagnosed with dementia, diagnosed with PTSD, diagnosed with neuropathy or whatever it might be. The petitioner is his daughter, a resident of Alabama, over age 21 and not ineligible to serve. And she's asking the court to be appointed his conservator for the following reasons. And then we outline his behavior, what he's done or what he hasn't done that he should have done. And if we have something from his doctor saying, Mr. Smith is my patient and he's been diagnosed with dementia or, frontal lobe, whatever, and can't make financial or other decisions, we'll attach that. And then we have to outline what his assets are, if you know those, and sometimes you do and sometimes you don't. And we say he needs help managing his affairs because his financial affairs, because he's making gifts to Nigerian princes or Jamaican con artists or the Publishers Clearinghouse, or he, he's a threat to lose his life savings because a caregiver, much younger woman, has moved in and is trying to establish residency there against his best wishes. The court immediately appoints what's known as a guardian ad litem, which is usually a lawyer, might be a social worker. Their job is to make sure that this proceeding is in the best interest of the person. They're called the party in need of protection. The court will also appoint a court representative, and that's usually a lawyer, who is there to make sure that the person's rights are not being violated. That, this petitioner isn't secretly just trying to get his disability check. So poor old dad is now chained to the radiator in the basement, and the whole purpose of this is to take control over their assets. So the court rep's job is to make sure his civil rights are being observed, and the guardian ad litem's job is to make sure that this is really truly the least oppressive option available. The guardian ad litem will usually meet with the party in need of protection, meet with the person petitioning, and might meet with the doctor or the practice at least to see what the chart is. Matt Talley, who used to work with me years ago, does a lot of guardianship conservatorship work as the court rep or the guardian ad litem, and he's really good at this. But there are lots of other people who are on the list. About a month after we file the petition, we have a hearing. And usually the person petitioning the court will be there to testify. Sometimes the party in need of protection will be there, and sometimes they won't. And it's a fairly short hearing usually, where if I were the one filing the petition for a person, I'd call the petitioner to the stand and basically go over everything we've alleged. Who are you? What's your relationship to the party in need of protection? Why do you think this is necessary? What are some specific events that made you aware that this is necessary? Who is your dad's doctor? What does the doctor have to say about this? And then if there's anybody who's trying to contest your appointment, they'd have a chance to testify as well. Once you become guardian and conservator, though, you're in charge of everything. You're in charge of every dime that comes into your dad's account. In fact, your dad, if a conservatorship is granted, your dad doesn't have the right to any of that money unless you approve it. So there's no credit card anymore. There's no bank account anymore. I mean, it's in your name and you're completely in control. After 90 days, 60 days in Shelby County, you have to submit what's known as an accounting or an inventory to the court. And it basically says, I was appointed conservator 60 days ago. And since then, I have become aware of the following bank accounts, CDs, stocks, bonds, mutual funds, real estate, whatever it is, in my dad's name, the party in need of protection's name, and they total up to this amount of money. The court will then either increase or decrease a bond that you've had to post based upon the value of those assets. And then every 3 years after that, you have to follow up with an accounting saying, over the last 36 months, this is how much money's gone out for the following purposes. This is how much has come in from the following sources, and this is how much is left. And that's done until the person dies. And then you have to do a final accounting, which says this is how much is left in the estate. And then it's paid either into his estate account that's already opened or paid to the executor if there is one. And if there's not, then it's paid to the administrator. So guardianships and conservatorships have become much more prevalent because of dementia. 20, 30 years ago, people just keel over from a heart attack or a stroke. They were perfectly healthy until that moment before they died. So guardianships and conservatorships weren't necessary, but with dementia being so prevalent now, people lose their capacity long before their physical body wears out. There's some big changes in place too for guardianships and conservatorships. We'll know more about those soon, but essentially what the state is considering is a list of checks and balances that will be put into place to protect people who are under guardianships and conservatorships from family members who might take advantage of them. So it's going to be a lot more reporting requirement in place. It's going to be a lot more monitoring in place. And unfortunately, that will probably also drive the cost up a little bit. So we'll probably, Sean and I will probably come up with a presentation once those are in, firmly in place to talk about the changes for guardianships and conservatorships.
Yes, absolutely.
The next area is estate planning. And of course, that applies to everybody, not just seniors. But for seniors, you know, I've had people come into my office who are in their 80s and say, well, we need a will. I say, well, what's wrong with your old will? Well, we never had one. Well, this guy's 80 years old. He's never had a will in place. You know, dying without a will is the most expensive way to go, no matter how old you are. But dying without a will could double or triple the cost to your estate that having a will could protect. And yet people don't know that. So estate planning, especially for seniors, is all about protecting the surviving spouse and then making sure that the assets pass to the appropriate people after both are gone. And what we've been seeing lately, a lot of is second and third marriages. People, you know, they lose a spouse. Either they got divorced or one of the spouses died. And now in their 70s or 80s, they've decided to remarry. Well, my advice is shack up, don't remarry. But if you can't live with that and you have to get remarried, at least come talk to us about what plans need to be put in place. Because in remarriages, each of the respective spouses might have children from their former marriage. And these kids, you know, they're adults now. They didn't have that growing up relationship that they had with their siblings with the stepkids. So when the first spouse dies, well, everything is probably going to pass to the surviving spouse and then to his or her children without having plans in place. If you put plans in place, you can at least protect your children from losing a share of the inheritance to the other set of children. But people don't think about that. So in second or third marriages, estate planning is critical to making sure that your kids are taken care of if you were the unlucky one to die first. Everybody should have a power of attorney, and yet a lot of people don't. And what a power of attorney does is it says, if I'm unable to manage my financial affairs, I want my son, daughter, spouse, niece, nephew to be in charge. They're called an agent under a power of attorney, and they can pay your bills. They can deal with, you know, your property taxes. They can open and close safety deposit boxes and do all the usual stuff that you take for granted. They can also help with a Medicaid application and help establish a special needs trust with the Alabama Family Trust and a qualified income trust with a bank to help you get a Medicaid application approved. If you don't have a power of attorney in place and you need Medicaid, then we have to go back to the conservatorship angle that we just talked about to get you appointed conservator just to deal with that Medicaid application. And that can be a $3,000 cost and a month delay in a Medicaid application that if you have a good power of attorney in place, you can avoid that expense and delay. Now, not all powers of attorney are alike. Just want to make sure you understand that. A power of attorney has to specify that power to help with a Medicaid application, to help establish a trust, to help me qualify, including qualified income trust, et cetera. Most of the powers of attorney we see don't have that because most powers of attorney are done for people y'all's age, not seniors. It's just not considered. So even if a person has a power of attorney, it pays to have it reviewed before they actually need to rely on it, just to make sure it covers all the bases. The Alabama Advanced Directive for Healthcare, as many of you know, is the document that says, if I can't speak for myself medically, I'm in the hospital, I'm not at death's door by any means, but I can't speak for myself, then I want my spouse, I want my daughter, I want my son to make all those medical decisions necessary until I'm able to speak for myself again. And it also gives them the responsibility, you know, to carry out your living will wishes about end of life care. So if two doctors say you're terminally ill or permanently unconscious, then, and you've said, I do or don't want to be kept alive artificially, it's their job to make sure that your wishes are carried out. So it's a very important document. And it, with the HIPAA waiver, the last one here, the HIPAA waiver says that you understand that your medical condition, your treatment, your diagnosis, your prescriptions, all that stuff is confidential, and nobody gets to know what's going on with you. You understand that. However, you're waiving that and saying it's completely fine with the hospital, doctors, pharmacy, nurses, therapy to discuss freely your medical condition with the following people. And then you have your spouse, your children, anybody else you want to have on there. And that way they're not going to be hit with a brick wall if they call the hospital and say, how's Joe doing? Well, we can't discuss that with you. That's protected by HIPAA. Well, if you signed a HIPAA waiver, at least Joe would be able to know. Now, it doesn't give Joe any decision-making authority with that information. It just says Joe is okay to know why I'm here and when I'm getting out and what's going on with me. Very
Bill,
important.
we have a question.
Yes.
It's what about the Alabama surrogate form if no DPOA? And is it ever legal for a non-blood relative to be a surrogate?
So the Alabama surrogate form is something we've talked about. It's not in the law in Alabama. Some states have it, and it's a way for you to share decision-making with someone else, or to give someone else decision-making authority if you have a lack of capacity. Alabama does not yet recognize that, although some states do. Anybody can be a surrogate. It doesn't have to be a relative at all. My understanding is in the states that recognize it, that it's done because many people don't have children, or their relationship with their children might be strained or not very close. So you can appoint anybody to be your surrogate. And I would imagine Alabama's going to adopt it. I know it comes as a shock, but Alabama is sometimes slower to adopt things like that than other states. And the last is probate of estates. And that's usually.
Bill, another question. Are you licensed in Tennessee?
No, I'm not.
No, okay.
I can certainly refer you to someone in the network, though, who would be a good person to call. I'm sure in social work and nursing, there's networks, under somewhere that that most people don't. And same with estate planners and probate lawyers and elder law attorneys. So we can usually fast track that referral for you if and when the time comes. So if you need somebody in Tennessee or really any state, just let me know. I might not know them personally, but I will know of their references. In probate of estates, these are broken down into two. I guess there's a fork in the road, so to speak. One fork is probate with a will, and the other fork is probate if there is no will. And it's amazing how many people still die without having a will in place. We have a case right now. It's a divorced man, 2 adult children. He died and his estate's worth $1 million. He didn't have a will. Well, one of the daughters lives out of state, so she can't possibly serve as administrator of his estate, no matter what she does, unless she wants to move back to Alabama. The other daughter can't get a bond because of maybe slow credit or whatever. So she can't serve as administrator either. Well, what do you do then? Well, now we have to rely on the county to appoint the county administrator over his estate. And his or her job will be to liquidate everything, regardless of what the kids want, and then divide the money between the 2 kids after all creditors have been paid, after the county administrator has gotten their money, after the court's gotten all their money, and after the taxing authorities have gotten all their money. Well, if we asked this poor guy who died, would you rather your daughters be your executor? He would probably have said yes. Would you rather not to see all this money go out the door needlessly to pay all these costs? Well, sure I would. But it's too late now. So
we have a question, another question, Bill.
Okay, great.
Are there laws in Alabama that will be used to prosecute powers of attorneys that misuse the resources?
Absolutely. There are 2 basic laws in place. There's protecting Alabama's elders, which is a one, and then there's an injunctive relief, which can result in more than that, where you can file an injunction against someone who is abusing their authority. And that person has to come before the judge and explain to the judge, well, yeah, I was telling Sean before we started, we had one agent under a power of attorney who decided to use the principal, the person's money, to replace their entire septic system. And the principal didn't even live with the agent. So that would be considered an abuse of their authority, misuse of funds, and prosecutable by law. But yes, there are means in place to protect families, and anybody can bring an action against the agent under a power of attorney. You don't have to be one or the other. You can be a friend, family member, and raise the issue. And the good thing is, there is no liability that attaches to you by bringing it up. So if you said, I have reason to believe Joe over there is misusing his authority or abusing his authority under a power of attorney and using her money to benefit Joe and his kids. Well, if it turns out to be not true, before you could be sued for slander and libel and all that. Now you can't. You're off the hook, because the law says anybody who is an informant is exonerated from responsibility. So no reason not to bring it up if you have even some inclination it could be taking place. I think the thing to remember about probate is it takes about a year if there is a will, and can go fairly easily if there is a will. That is very, very few, if any, court appearances. And you can run things yourself without the court telling you every step of the way. When you die without a will, though, it takes about twice as long, cost 3 or 4 times as much. And you have to go back to the judge every time you need to do anything to ask permission. So a will alone might cost $500 or $600. Probate without a will could be $5,000, $6,000, $7,000, $8,000. So people who are being penny pinchers by not having a will, they don't know the whole picture. They're going to spend a lot more than what that will is going to cost them if they die without a will. Not to mention the trouble that they're going to create for their next of kin, their loved ones. And we do a lot of probate as well. It's part of working with seniors, really is. So that's who we are. That's what we do. Our office is over in Office Park in Mountain Brook. We used to be up in Hoover, moved over here 2 years ago, and happy about the move. I'm not the only lawyer here. Jennifer Taylor's also a lawyer, and she's younger than me, and with any luck, she'll be around for a lot longer than me. My wife tells me I can't retire anytime soon, though, so I'm going to be doing this for the immediate future regardless. Happy to answer any questions you have. This is our website. We have a substantial blog, and we post there all the time. We also have a Facebook page under Alabama Elder Care Law Firm, and we post articles there all the time. And you're welcome to call or email us with any questions you might have. Always happy to be a resource.
And Bill means that, y'all. So y'all do please take advantage. And in terms of being, a lot of material, Bill is I won't say frustrated necessarily, but is a writer, an English major at heart, and loves the written word, and he writes well and writes often. So I'm sure you all can find many, many helpful articles at his website, and certainly he would be happy to talk with you. And I'll tell you, many elder attorneys in the area who have worked with and known will charge you for your hour to just ask whether or not you have a case or what to do, whereas Bill will gladly take a call for a half hour at no charge. And he's always done that. And I'll tell you, that is so helpful to people in crisis, the people who, we help at Care Patrol, to know that they can have an ear and get some guidance and know, what to do in the immediate and near future, as well as the future, the beyond near future. And so Bill is an excellent resources for you all. And I appreciate so much, Bill, you doing this twice this month with us and sharing your experience and expertise and knowledge with me and with, you know, all the people who've been privileged to be on the call. There's, as you look at the chat room, a lot of people thanking you for the information, and I thank you. I don't know that I've given out the code word yet, y'all. I apologize. I did put it in the chat room. It's SAVE, S-A-V-E. And what I mean by that is you can save money and time by visiting an elder lawyer before you need one, not after you need one. It's sort of like insurance. When the tree has hit your house, it's too late to get insurance.
Yeah.
SAVE is the password. I've posted and I'll post again the Survey Monkey link, which is https://www.surveymonkey.com/r/ all uppercase WVR522Y. That's our Survey Monkey link, and the password is SAVE. The password is necessary to open the evaluation. It's also a required question in the evaluation. And the reason Cassandra can't get it to work. Is anyone else having problems with Survey Monkey? Shouldn't be a problem. I know it's open. Let's see, analyze results. Oh, no, I think it's working, Cassandra. Maybe cut and paste again out of the chat room, if that works, or I can read it out to you again. Oh, it's working. It's working. Don't use all caps. Just click the link in the chat, everyone says. So thank you all again for being here. We've got one more session this month. Next week is reverse mortgages. So a little departure from our law. We're moving into finance. I think we'll move that way here possibly in May. And then in June, we're going to have all ethics month in June. They got some really good folks presenting, one of whom is a doctoral candidate in social work presenting on social worker ethics. So don't miss that. Look for our calendar of upcoming CEU events at carepatrol.com/advisors/Sean Barnes or something like that. I'm sorry, I don't know my own website address, but I know it. If you click on my face, my face, which you can see here on the screen, pulls up on your screen, click it, and you'll get to our calendar. You'll also find recorded CEUs there. So if you've missed one, heard about one, see one that you wish you had seen, see if it's recorded. If not, I'll send you the recording. You can get a recorded CEU. However, today's CEU is live. It's live because you've been here. We know that you've been here because you have the password of SAVE, and we know that you've been here because you are or will complete the evaluation. ABN number, Cassandra, is the Alabama Board of Nursing. If you don't have one, just leave it blank. Well, thank you all again. And thank you, Bill, again. I appreciate you so much. I learned a great deal today, and appreciate all of you for being here. We'll see you next week, and y'all have a great weekend, and hopefully it'll be beautiful and sunny and a little warmer for us all. Y'all have a great evening.
Thanks, everybody.